Hello, and welcome back to another episode, our third episode, in fact, of Legally Brewed, where we're going to be steeping ourselves in the law, one issue at a time. I'm your host, if you'll remember, Sandra Grace of Florio Perucci out of Cherry Hill, New Jersey. And today we're just going to go on a myth busting mission together. Uh, you know, there are countless legal myths floating around, whether it's snippets of advice, warnings, old wives' tales, if you will, that we take for face value. But really, how much of these are actually true? How much of these actually have some merit in them? So today we'll likely get started on what will possibly become a series down the line as to some common legal myths. We'll try to set the record straight and just get started on some things that may or may not be true. So, first up, let's talk about some consumer rights. Consumer rights, heard it, you've heard it. One common myth is that the customer is always right. So the customer, whether it be with a retail business or even in restaurants, when it comes to disputes with businesses, is apparently always right. And while it's a great slogan for businesses and again these retail locations to kind of always say, you know what, we're always going to make you happy. The customer is in fact always right. Legally, it's really not that clear cut, and uh, unfortunately, for all of us who are not in the legal field, you're going to hear me say that a lot. Things are not as clear cut. Things are not as black and white as we often would like them to be. And just as that's a common theme. That's really the first part as it relates to this myth about consumer rights. That legally, when it comes to disputes with businesses and customers, it's not really always that black and white. And mainly it's because there's consumer protection laws, and without really getting into much detail, because the lawyer answer is always it depends on a case by case basis. These consumer protection laws oftentimes they provide a lot of safeguards for both the consumer actually and the business, but they don't necessarily always make the customer automatically right in every single dispute. Just a very, very brief example, right? If you, as the consumer, you break a product and then you try to return it, the store, again, we're gonna put the disclaimer of it depends, but the store might not necessarily be required to accept the return, despite what you may have heard with the slogan that the customer is always right, right? So I'm not saying hire a lawyer and go about a whole investigation to figure out if you can return a broken product, but I'm just saying it's not necessarily always that clear cut answer that, you break it, you can return it. Another common belief as it relates to consumer rights is that you can return any item within 30 days for a full refund. This one is actually, again, it's very dependent on the store's return policy and as always, state law. So, some stores could potentially offer that 30-day return policy, but it's not necessarily a legal requirement everywhere. So again, you have to, on a case by case, on an it depends basis, check the specific return policy at the time that you make a purchase. I always just out of sheer habit, I always look at the return policy before I make a purchase, just because I want to be able to point to something and I want to just make an informed purchase. If I'm looking at different stores, for example, and that's something that's going to make a difference to me, then that's some research I want to do beforehand, before I even make the purchase and I'm faced with having to potentially make that return. So just some minor examples for you as it goes. to consumer laws and returns and such. Just some considerations for the average Joe out there. Now let's move on to another myth. This one more related to employment law. Nowadays, with remote work and people having company devices, that's something obviously that's a lot more prevalent now than it was even 10 years ago. But fortunately, there's some misconceptions that anyone who has a company-owned device, like a laptop or a phone, for example, company-owned, again, that you have complete privacy. Unfortunately, that's not the case, right? Aside from the fact that the device is very much literally owned by your employer. In addition to that, employers often have policies surrounding the monitoring of these communications and activities on your devices. And when I say monitoring of all communications, we're talking emails, messages, text messages, browsing history. All of those are fair game because, again, we're talking about a company-owned device that they are giving you to conduct your business. So, not much, it depends here, other than just make sure that you're using your devices that are given to you by your employer in a manner that coincides with your policies and just your employer's needs, right? Based on your policy, you could give them cause for potential discipline or even termination if it persists. So you just want to make sure that you're really mindful of that. And just because you can't tell that your device is being monitored doesn't mean it's not. So just throwing that out there for everybody who might think that it's not necessarily a consideration. And then, just something that's come up more recently, I think, with what's called salary transparency at this point. Another widespread myth in past years has been that it's illegal to discuss your salary with coworkers. But in fact, there's a specific law. It's called the National Labor Relations Act, where most employees have the right to discuss wages and working conditions with their colleagues. Now, this is, there could be potential exceptions. Check with your state law, or your employer's policy. Again, I'm going to give that caveat, but there's really this push for salary transparency, and to ensure employees who are seeking to improve their work conditions or negotiate better pay. So there's nothing necessarily at least as it relates to this, again, National Labor Relations Act that prohibits the discussion of salaries and working conditions amongst colleagues. In fact, again, it promotes it just so people can have better working environments. Moving on to one that you've probably seen or wondered about in TV. So we're talking about myth number 3 over here, criminal law. So, we're always hearing about Miranda rights. If you're watching TV, hopefully you haven't been subject to an arrest yourself, but you're always, when you're watching a show or something, you're like, oh, you didn't read them their Miranda rights. That's completely invalid. And, you might, again, think that if you're arrested or if somebody is arrested and they're not read their Miranda rights, that the entire arrest is invalid. But believe it or not, and I'm one of the people who, before I went to law school, I didn't believe this from watching all my shows, but that's a misconception. Yeah, Miranda rights are crucial, but they only pertain to interrogations. So they need only be read before an interrogation. If the police arrest you without reading these rights, it doesn't necessarily invalidate the arrest, but it may prevent them possibly from using any statements that you say as evidence um, against you in court, right? We'll dig into this a little deeper. Like I said, I'm really hoping to make this into somewhat of a series and really delve into these misconceptions. But just as a pointer that these Miranda rights, they refer to interrogations and statements, but not necessarily the arrest. So just keep that in mind. And then here's a fun one. We're mixing kind of criminal law with traffic tickets, but there's been this myth that a case has to be dismissed if the police misspell your name on a traffic ticket or report, and that's just unfortunately for many of us just not true. Minor errors like misspelling a name or incorrect address don't generally impact the effect on the validity of a legal case, right? Oftentimes the courts are interested in some form of substantial justice and not just clerical perfection. But, I'm going to go back to my caveat always, depending on your jurisdiction, depending on how bad, I guess, the misspelling or the incorrectness is. And if you have a really good lawyer, then maybe you can get something dismissed. But generally, again, the courts are really looking for the substance and not necessary or unnecessary clerical perfections. Moving on, we got about 2 more myths left. This one, myth number 4, will tackle real estate law. A common belief oftentimes is that if you walk away from your mortgage, so you take out a loan when you're buying a house, and a mortgage is that you owing the bank or whoever you took that loan from. Typically, again, it's a bank. So a common belief is that if you walk away, just stop paying your monthly dues, that the bank just simply takes your house and that's the end of that, right? But believe it or not, if the bank takes over your house, tries to sell it, and that sale doesn't cover the amount of money that you owe, the bank can actually come after you based on your state laws. So keep that in mind. Again, I'm going to say it depends, but a lot of times the bank can have some remedies after selling your house if they don't make all their money back. So you might not completely be off the hook. Again, it's not always a clean break. So just, obviously if there's specific circumstances that don't allow you to continue paying your mortgage, just engage in conversations, engage some research. And obviously it's always best to try to seek some legal advice before, during, you're going through that process, because again, you could potentially have some more ramifications than just saying, bank, take my property. It's all yours. Just try to recoup your money, because they're going to try to recoup their money in one way or another. No one really likes losing. Banks certainly don't. So they're going to try to recoup their money by selling your property. But if they don't make it all back, then you again might still be on the hook. And then here's a fun one. Once you own a home, right, you're no longer in a rental property. You own your home and you feel good about it. And so many homeowners think that they could do whatever they want at whatever time they want on their property. But oftentimes, if you're in a townhouse, for example, you have homeowners association rules, right? But even more than that, say you just own your house flat out in a township, you have zoning laws and you have municipal laws and just general environmental regulations that can still place significant restrictions on how you can use your property. So, congratulations, you're a homeowner, but you want to build that gazebo out in your backyard. Call the zoning office. Check your local ordinances, right? Congratulations, you're a homeowner. You want to build that pool in your yard? Great, not a problem. You don't have a homeowners association? No problem, but you still have a township and local ordinances that you have to look into. And a lot of people, especially first-time homeowners, don't really take that into consideration, right? Even though it's almost the same if you were in an apartment, right? You want to do something, but you have to consult the rental agency or whoever you're renting out the apartment from. So it never really goes away, but just something to consider when you get your first, your second, your third home, so on and so forth. It's just, again, you never really escape regulations, right? And then lastly, let's just briefly dive into some family law, hopefully clear up some misconceptions. One persistent one that I've heard day in, day out is that in terms of custody and legal disputes where children are involved, that the mother always gets custody of children in a divorce. No questions asked, no bars held. And while there could potentially be some validity in that just historically, that's not necessarily the case at this point. There's tests by the court that are looked at, and we'll dive into those later on when we get into our family law segments. But there's what's called the test that focuses on the best interests of the child. Really, what's going to favor the child, their well-being, their health, their emotional being more. And there's no leg up initially, no presumption in favor of either parent. It's literally what's the best interest, what's best, what environment is the best for the child. And again, common misconception, not necessarily looked at in terms of mother, father, but again, where's the best location for the child or children to be? So just keep that in mind, moms and dads alike, when you're entering into these potential custody battles, because neither of you really have the leg up just because you're a mom or dad, right? And then finally, just turning into our gears into family law still, another widespread belief is that prenuptial agreements are really only for the wealthy. You have a lot of assets, if you have a lot of things that you just want to protect. And that just isn't true. While it could have been potentially, again, historically, just something that a lot of individuals with assets would enter into, just generally speaking, a prenup, as we call it for short, can be a practical tool for any couple to just set clear expectations and protections for their future. Obviously, if they decide to have children, take that into consideration. And a prenup also just doesn't necessarily have to cover division of assets. It can cover a lot more. And just set those clear expectations and those protections moving forward. God forbid something's to happen to that marriage, you just have something in place and you don't really need to rehash it. It's almost like some mitigation. You work on preparing things beforehand before you need, should your marriage go south, before you need a divorce lawyer to really put it together at the tail end, right? You're just preparing for it accordingly should it happen. And, should it not happen and you not need your prenup, that's fine too. Then you just have it on the side and you never need to look at it or use it. So that really covers just about 5 different areas of the law, 5 5 areas of myth busting. Like I said, the aim is to really make this into a series. Next time, we'll probably be talking. We'll take we'll take a detour and talk about it and have a full episode on different areas of the law. But thought it would be fun to do some legal myth busting and talk about some persistent misconception. And really shedding some light on these myths is not only broadens our understanding, right, but it also empowers lawyers and non-lawyers alike, right, in some daily decisions and interactions as it relates to the law or just people in general, right? But always, as I say, it depends, and a lot of times, and especially when in doubt, consult a legal professional and don't just rely on hearsay or things that you might have just been told throughout the duration of your life or expertise. Because again, there's people who actually do this. There's people who actually know about this, and while I hope that our little transverse into myth busting gave you some insight, there's definitely a lot more about these topics and about other topics that we haven't covered, that I can't even begin to fully cover. So, just always, when in doubt, talk to somebody who you think knows what they're talking about. Again, don't just rely on hearsay, as we like to say. So without further ado, thank you for tuning in to Legally Brewed. Join us next time. We'll talk about some more legal insights and demything or demystifying in the legal world.